As you are entering the seminar, I will start with a brief disclaimer. CLE presentations are intended for educational purposes only and do not replace professional judgment. Statements of fact and opinions expressed are those of the presenters individually, and unless expressly stated to the contrary, are not the opinion of the Florida Bar or its committees. The Florida Bar does not endorse or approve and assumes no responsibility for the content, accuracy, or completeness of the information presented. Any feedback should be provided to the event organizer. Good afternoon. Welcome to the Florida Registered Paralegal Enrichment Committee's April 26, 2024 free CLE webinar, Florida's Capital Post-Conviction Process. During the webinar, if you have a question for the presenter, please post it in the question and answer section at the bottom of the screen. Some of the questions will be answered by the presenter at the end of the presentation. Due to time constraints, there may not be time to answer all questions. At the end of the webinar, I will provide everyone with the course number, which you will use to self-report your credits in the member portal. I will now turn it over to the FRP Enrichment Committee Chair, Karen George.
Thank you, Diana. Before we begin the webinar, we would like to make you aware of our upcoming June 21st FRP Day at the Florida Bar's annual convention. The FRP Enrichment Committee will be at the Florida Bar's annual convention on June 21st at the Signia by Hilton Orlando Bonnet Creek in Waldorf, Astoria. Our committee meeting will begin at 11 a.m., ending at 1 p.m., and everyone is invited to attend. From 1:30 to 3:30, we will be presenting two in-person seminars. Josh Rosenberg will be presenting on estate planning, and nurse paralegal Elizabeth Alieri will be presenting on surgery to discovery, bridging healthcare and law, the role of a nurse paralegal. Registration is required as space is limited. Watch your inboxes for information for registration to save your spot. From 3:30 to 5:30, the FRP reception and announcement of the FRP of the year will take place. We offer hors d'oeuvres in 2 open bars. We look forward to seeing you there. We will not have a free CLE webinar in June. Our May CLE will be on May 31st from 12 to 1, and Kelly Rodnathy will be presenting on developing durable skills, professionalism, and ethics. Please watch your inboxes for registration. Please check out the FRP Enrichment Committee on all social media platforms. It is there you will find helpful tips and announcements of upcoming events and our monthly webinars. If anyone has a subject and/or speaker you would like us to present on our monthly free webinars, please reach out to Araceli Mayorga at newcreation427@yahoo.com. Now, today's speaker is attorney Julie Morley. Julie Morley is an assistant federal defender at the Federal Defender's Office for the Middle District of Florida. Ms. Morley works in the Capital Habeas Unit representing indigent clients on Florida's death row in their federal habeas proceedings. Ms. Morley was born and raised in New Jersey. She earned her Juris Doctorate from New England School of Law, where she was also the executive comment and note editor for the New England Law Review. Ms. Morley has been dedicated to representing indigent criminal defendants since the beginning of her career. She started as an assistant public defender for the 13th Judicial Circuit in Tampa, Florida, where she gained valuable trial experience. She then moved on to the Capital Collateral Regional Counsel's Office for the Middle Region of Florida, where she began representing death sentenced clients on Florida's death row in both state and federal post-conviction proceedings for over 8 years before transitioning to her current role as Assistant Federal Defender at the Federal Defender's Office. Thank you, Ms. Morley, for presenting today. I will now turn it over to you.
Great. Thank you for that introduction, and good afternoon, everyone. I am going to be giving you an overview about Florida's capital post-conviction process in both the state and federal grounds. So there's a lot to cover. We're just going to go forward. If you have any questions, please put them in the Q&A. Let's start. Okay. So today's presentation, I'm going to be going over death row, an overview, what capital crimes and trials in Florida look like, an overview of the appellate process after a trial, the state post-conviction process that happens in Florida, what types of claims that you would see in a petition for post-conviction relief, and then if there's time to talk about some issues that you deal with in federal post-conviction. So this first chart that I have here for you is to give you an idea as to the amount of people on death row across the country. This is a chart that was dated January 2023. All of my charts and graphics are coming from the Death Penalty Information Center, and I give them credit at the bottom of all these pictures. They're a nonprofit organization that has tons of valuable resources regarding the death penalty nationwide. They also collect statistics and do a lot of research projects. So they have a lot of information that's very helpful. As you can see, Florida is right up there with how many people we keep on death row. Although this says 313, I checked yesterday and the number of inmates on death row currently is 278. So it has gone down a little bit since last year. This chart, the death penalty is on the books for about half of the states currently, but only 28 states, the US government and the US military actually have people on their death row. Here's a chart about kind of the breakdown, geographic demographics of the type of prisoners that are on death row, and then giving a list of order. Florida's always been in the top, as you can see, which is why post-conviction is so important. So this death penalty is supposed to be reserved for the worst of the worst crimes. That's a phrase that you'll hear a lot coming out of any sort of case law from the US Supreme Court or the Florida Supreme Court. In Florida, the state attorneys, the local state attorneys have discretion to decide when they want to seek the death penalty in a case that's otherwise eligible for it. They do that by filing a notice that they intend to seek the death penalty in a case 45 days after a defendant's arraignment. What we have learned from different studies and research projects is that the factors that go into deciding how someone gets on death row or whether the state is going to seek death has to do, unfortunately, more so about race, geography, the quality of your trial counsel, and really just where you commit the crime itself. Here's a pretty scary statistic, but 2% of all of the current death row inmates come up from 2% of counties in the country account for 56% of all death row inmates. So you can kind of see there is an arbitrariness in determining what happens to you by committing a certain crime, depending on where you live. Duval County is number 8 in the country for attributing the death row inmates to the population. This other chart talks about same type of idea. These 9 counties account for 35% of all the death sentences in 2012. So that's fewer than 1% of all of the counties in the United States. Florida accounts for 3 different counties. So we have Sumter, Polk, and Duval. Those areas, you will see a higher rates of state attorneys seeking the death penalty on the criminal defendants. To understand the capital post-conviction process in Florida, you do need to have an idea of a general overview of capital trials. This alone could be its own CLE, so I'm not going to be spending much time on it, but I am going to just give you a quick overview of what it looks like in Florida so it makes sense later as we get into the post-conviction. So what crimes can result in the death penalty? In Florida, it's first-degree murder, so that counts as premeditated murder. Felony murder, so that's a death that occurs during the commission of an enumerated felony in the statute, or a death that's caused by the distribution of a controlled substance. Also on the books, and this is why I have a little question mark next to it, it got passed last year in 2023. The legislature added sexual battery on victims under the age of 12. This was passed last year. There's only been one state attorney in Florida who has sought death against a defendant for this crime. That happened in Polk County at the end of last year. That case has since resulted in a plea negotiation and death was taken off the table. We're going to see some concerns with this because there is U.S. Supreme Court precedent that this is unconstitutional. The Florida legislature, when they passed this, believes that the prior U.S. Supreme Court case was decided wrongly. So they have passed this legislation. I would expect this is going to get challenged very quickly as soon as someone actually gets convicted under it. So be on the lookout for that in the news. So who cannot get executed? If you're incompetent at the time that the governor signs a death warrant, you are not eligible to be executed. If you're intellectually disabled, also known as mental retardation, you can't be executed. If you were under the age of 18 at the time you committed your offense, and non-homicide rapes. And this was what I was referring to about the new statute that we just passed. So those are on the books right now of people who are ineligible to be executed. In Florida, we have a bifurcated system regarding trials. And that just essentially means that there's two trials when you have a capital case. First part of the trial is just the guilt and innocence phase. What you think of typically for a trial. Did you do it? Did you not do it? You need 12 jurors to vote for this, unanimous, just like a normal trial. The second trial is what's referred to as the penalty phase. It's the sentencing portion of the hearing. So in a penalty phase, there's a presentation from the state of evidence that support certain aggravating factors that could enhance the penalty to a death penalty. The defense will put on presentations of mitigating factors, which will weigh against a death sentence and in favor of a life sentence without the possibility of parole. The current law in Florida, and current as of 2023, again, it was a busy year for the legislature, 8 out of 12 jurors on the jury pool have to vote for death for a judge to impose the death sentence. Something just of interest to note is that Florida is just one of 2 states in the country that allow a non-unanimous jury recommendation for death. All others require 12-0, the other state being Alabama, which requires 10 to 2, 10 jurors to vote for death. I'm not going to go through this, but it's in the slides and you'll get a copy of my PowerPoint afterwards. But these are the list of aggravating factors that the state looks at in order during the penalty phase. The finding of one has to be unanimous by the jury in order to make someone even eligible for the death penalty. Some of the ones that you'll see pretty regularly are that the crimes were committed were especially heinous, atrocious, or cruel, that they were cold, calculated, premeditated. The client was previously convicted of a prior violent felony, things of that sort. The mitigating circumstances, same thing. So this is evidence that the defense would put on to support reasons that a person should not be sentenced to death, but should be given a life sentence instead. And there's lots of different options here that you'll see here. No history of prior criminal activity. The defendant couldn't appreciate his or her conduct, was under extreme duress of another person, or the catch-all at the bottom, any other factor in the defendant's background that would mitigate against the imposition of the death penalty. So what happens after someone is found guilty and sentenced to death? There is a direct appeal that goes direct to the Florida Supreme Court. The Florida Supreme Court has original jurisdiction to hear all capital cases, so we skip the District Court of Appeals entirely in Florida and go right up to the FSA. When we get there, there is a direct appeal petition that's filed, and in there the issues are looking at errors that occurred during the trial, something that you would just be able to see, but from reading the record, black and white. So types of errors that you would see would be the trial court erred in denying a motion to suppress. The trial court erred in overruling an objection made by the defense. Errors that the trial court made in its sentencing order, things of that nature. An oral argument is typically held, and then after the oral argument, the Florida Supreme Court issues an opinion. If the relief is denied, then a mandate and an order appointing post-conviction counsel occurs. So what happens after the Florida Supreme Court affirms the conviction and sentence of death? It's post-conviction party time. This is where we come in, and this is my favorite part. So this, I'm a big picture person. When I first started post-conviction 12 years ago, I need to visually see what's going on, big picture, to make it make sense to me. If you do any sort of post-conviction work in Florida, you're going to be coming across a chart that looks like this. This basically shows the way a case goes through the appeal process in direct appeal and post-conviction appeal from start to finish in Florida. The first two columns are state court related. The last column is federal court. So, and they go up as the level of appeals court gets higher. So the first box is where we're in the trial. If they're found guilty and sentenced to death, they go to the direct appeal to the Florida Supreme Court. If they deny it, they're able to file a petition of writ of certiorari to the U.S. Supreme Court. Box 4, you're back at the trial court again, but now you're there for post-conviction proceedings, which we'll get into more. When that gets denied, you can appeal again to the Florida Supreme Court. If that gets denied, again, you can appeal to the U.S. Supreme Court. Box 7, you start back at the trial court level again, but now you're in federal court. You're at the federal district court level. If a petition of writ of habeas corpus gets denied, you can appeal to the 11th Circuit Court of Appeals, which is the Circuit Court of Appeals in our district. And after that, the U.S. Supreme Court again, 3 times at the U.S. Supreme Court. As you get through this process, the further and further you get away from box 1, 2, 3, the ability to get relief it gets much harder because the standard of review gets harder, the burden gets higher. It's very difficult. So quick overview of the state post-conviction proceedings. After a client's conviction and death sentence has been affirmed by the Florida Supreme Court, state post-conviction counsel is appointed. Everyone in Florida is entitled to counsel for capital post-conviction proceedings. The defense team conducts extensive records review and independent investigations, eventually filing what's called a motion to vacate judgment and sentence. The court will then conduct an evidentiary hearing on claims raised in that motion. The trial court will written an issue order following the evidentiary hearing. If the order denies the relief that the defense was requesting, counsel then can file a notice of appeal to the Florida Supreme Court. That's big picture overview, and we're going to get into the specifics of it now. So I don't have a lot of statutes and rules written down in this presentation because that's pretty boring, but there are some that are so important that you can't ignore. And if you're going to do capital post-conviction, the rule of criminal procedure 3851, you know it inside and out. I am constantly rereading this rule. I've read it hundreds of times and I still go back to rereading it. It covers everything to do with post-conviction in Florida in the state setting. So it governs appointment of counsel, court hearings, how the records are going to be collected by the clerk, time restraints, pleading requirements for the motions, for your first motion, any successive motions, how courts are supposed to dispose of claims, evidentiary hearings, the requirements for expert and witness lists, the requirements for how expert witnesses can testify and types of reports they need to issue, what to do if your client is incompetent during capital post-conviction proceedings. It also covers what happens when the governor signs a warrant of execution during that litigation time, and it covers the voluntary dismissal of post-conviction proceedings by a client. So Rule 3851 gives post-conviction counsel 1 year after the judgment and sentence become final to file a motion to vacate judgment and sentence. So that's not a lot of time for all the work that we have to do to file that motion. So when you get a new case, you're hitting the ground running, and it's just going nuts for a year and to get everything you need into that motion. So these are the sort of things that we're looking at when we say what you need to do within this year. Records, 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 records. If you were thinking of entering post-conviction litigation as a career opportunity and you don't like reading records, you should probably do something else. All my poor paralegals have boxes and boxes of banker files in their offices with indexing and scanning. It's a lot of records. So I fortunately love records. So this is right up my alley. First thing to know, the other important rule is Public Records Rule 3852. So this rule discusses the central records repository and governs all the post-conviction record collection from local and state agencies involved in the case. So any state agency that was part of the case at trial or through the discovery process, the investigation, anything that happened at the trial level will have to submit all of their files to this records repository, which is housed in Tallahassee. The records repository then indexes the files and sends them to post-conviction counsel. These will include state attorney files, medical examiner, Department of Corrections, all local law enforcement agencies, FDLE. Those are the main ones, but any other state agency that was involved has to submit these records. Under this litigation, when you're in 3852 land, if agencies feel like things are confidential and should be privileged or exempt, they can put them under seal when they submit them to the repository. If defense counsel feels like certain agencies were left out or they didn't give everything that they had, there's mechanisms under this rule to allow for additional requests for public records. There's litigation rules about how to get records unsealed that defense counsel feels should be not considered privileged and be used as part of the post-conviction litigation. It's a lot. It's a lot of records, and it could take up several months of the beginning part of the post-conviction process. There are also separate rules regarding records litigations dealing with when death warrants are signed. One of the important parts of 3852, they created the centralized record repository because in the early 90s, there was a disaster with trying to get records and what was able to be received. So having it in one central location has made everything streamlined, but you only get one shot at it for the most part. So it's really on counsel and defense team to make sure they're requesting all the records that they need during that time period that it specifies. Okay, more records. We're also seeking trial attorney files. So whoever the trial attorney was, their defense team, they have to give a copy of their complete file to post-conviction counsel. And out of all the records, these are my favorite. These are gold mines of information because you're seeing not just pleadings that they filed and transcripts that they got from depositions. You're getting correspondence between them and the clients. You're getting handwritten notes. You're seeing memos, their impressions. You're going to get to see witnesses that they interviewed or experts that they interviewed with or consulted with, but they never used. And you can really see a lot of where the strategy and the thinking is coming from the trial attorney or lack thereof. So in the past, when I've done this, gotten these files, I found fun things like clients asking their attorney to go seek a deal with the state, and the attorney never followed through with that. I have found a memo from a phone call with an expert witness saying brain scans need to get done for this client because of suspected brain damage, and the attorney never followed through with getting the scans done. I've seen letters from witnesses saying they can provide an alibi, and the attorney never interviewed those witnesses. And I've also seen notes from a phone call about the main eyewitness to a crime who says she's having doubts whether she picked the right person out at trial, and the attorney never followed up with interviewing her or bringing her in during post-conviction proceedings. So you really can get a lot of great information that's helpful for future claims in your motion here. This should also include files from investigators on the team, mitigation specialists, or experts. If it's not part of the trial attorney files, then we have to ask for those separately and contact them to get those files as well, to get a complete picture. Because a lot of times, people on the defense team are not working in harmony, as you can imagine. So even more records. There's also something called a record on appeal. The clerk of the trial court completes a record on appeal when a case goes to the Florida Supreme Court on direct appeal. This will include everything from arraignment to when the notice of appeal was filed. So we're talking everything that touched the clerk's docket gets PDF'd and put into one document sent up to the Florida Supreme Court, including all the transcripts from every hearing that ever happened at the trial level. So this is thousands and thousands of pages on its own. The records repository used to collect this, but now more often it's just found on the Florida Supreme Court website. You can just download it. Anyone can download the record on appeal, unless it's, there's parts of it that may be under seal for different reasons, but it's all PDF'd and up there to review. At the end of post-conviction proceedings, a similar record of appeal gets created by the clerk and sent up to the Florida Supreme Court again. So could there possibly be even more records left to find? Always, always, always. Other valuable records. Now, these are records that maybe weren't part of the trial originally. Maybe the trial attorney got some, but not all. I don't know. But personally, I want every piece of information that's out there with my client's information on it, or related to my client in any way, related to his family, anything. So we're looking at, these are just some examples of things that we'll go after. School records, employment records, medical, social media accounts, records from co-defendants of their criminal histories, Department of Children and Family, all of these listed here. All are related. Anything that could possibly have any significance to guilt or penalty phase is relevant to me, and I'm getting it. These records are even more important to get in post-conviction because unlike the state agencies that have very high retention requirements of keeping these records basically indefinitely until a death sentence is carried out, these non-state agencies don't have those same requirements. So they could easily get destroyed in the normal course of their business proceedings, maybe 7 years, 10 years. So when I'm getting cases maybe that are 15 years old, and if these records hadn't already been sought after, a lot of times they're gone forever. So you want to get them as early as you can as possible. An example of some of these, why they're important. So the Judicial Administrative Commission, if the client had say a registry attorney that was appointed for him at trial to represent him, he has to send billing records into the JAC. I like those records because I want to see how much he billed for. I want to see what he's billing for. I want to see other cases that he was appointed to that he was billing for at the same time frame to see if it was possible that he or she was working like they said they were. Florida bar records, same thing. If that attorney, the trial attorney was sanctioned, if he was disciplined, I want to know when he was, why he was. because that could all be relevant to the kind of representation that they gave my client during trial. Criminal records from other client cases. A lot of times the state will use prior violent felonies as an aggravator at the penalty phase presentation. I want those records to see were the facts as the state presented them of those prior violent felonies exactly what they're saying, or are they being exaggerated? And then a lot of this is good. A lot of these stuff are good for mitigation purposes, things that could go towards why your client shouldn't be on death row, but should be getting a life sentence. Medical, school, anything that show histories of trauma, of mental illness for himself or herself and their family. These records are also a great resource to trigger finding more records. If there's something in here that references another report that we don't have, we go down that rabbit hole. And they're also a great resource for finding new witnesses. You can go to the school records and you can find teachers that maybe were never interviewed but were mentioned in the school records. DCF, if there's a caseworker name on those records, I'm going to try to track down and interview that caseworker. So investigations. So we have all the records now. So what are we doing with them? Post-conviction, at its finest, takes a scorched earth approach. So we're investigating and reinvestigating every aspect of the case, whether it had been done before or never done at all. So, and I list some examples here of locating and interviewing former witnesses or new witnesses, interviewing all prior actors in the case, finding and consulting with expert witnesses, and re-reviewing all the forensics. A lot of people like to call post-conviction Monday morning quarterbacking. You know, we know something went wrong when someone was found guilty and sentenced to death. So they already got the worst possible outcome. So now we're trying to figure out what could have been done differently, what could have been done better, what new things exist that maybe a judge or jury never heard, that upon hearing it would have changed their opinion as to the outcome of the case. So we want to see what was done and why and what was missed. So investigations can be anything. And I'll give you some examples of typical ones that I've seen that I've done. One of the reasons we get the trial attorney files, part of their files includes a complete copy of the discovery that was given in the case. So when we get the records from the records repository from those same agencies, we can do a side-by-side comparison to see, did this trial attorney have everything that the agency is giving us now? Do these records look different? Are they altered? Is there more stuff in there that wasn't there before? Because that could potentially set up for a Brady violation, that the state was withholding some information that they had at the time of trial. We will re-interview all witnesses again. Has there been any information that they didn't testify to? Maybe they weren't asked the first time. So some witnesses are only going to give you exactly what you ask. You ask different questions, you may be prompting different answers. Are they changing their story now? Do they want to recant their prior testimony? Were there things about these witnesses that weren't brought out in cross-examination? Potential bias issues? Was there a deal with the state that they got for their testimony that we only are learning about now years later because they're further away from it and maybe feel more comfortable talking about it? We're looking at why certain witnesses who the trial attorney knew about never called them at trial. What were the reasons behind that? Would it have been better to put them on the stand? We're contacting experts. So we're looking at the original experts that testified at trial in the guilt or penalty phase. And we're asking them, were there any problems with the case? Was there any information that you wanted that you didn't get? Has the science changed since you have testified that would change your opinion today? We'll get new experts on boards. Lots of times I don't like the experts at trial. I'll bring on my own experts. I'll have my expert look at the raw data from the former expert and tell me, was there any errors that they had in their trial testimony or the way they scored their testing? We can obtain personnel files for state witnesses to see if there were any disciplinary actions that should have been brought out at trial. Or we're just looking at finding brand new evidence entirely, things the trial attorney just didn't get the first time around, or maybe things that didn't exist the first time around. It's really endless, the type of investigations that you can do in post-conviction. So all these investigations, all of these records that we're collecting and reviewing and indexing so closely, all lead us to the main show in state post-conviction, which is the motion to vacate judgment and sentence. That motion is the main vehicle to attack your conviction and your sentence of death in Florida. It is discussed in the Rule 3851, exactly what you need to put into it, how you need to plead it, page requirements, all that stuff, time restraints. What we're looking about is what types of claims are we going into? So we have all these investigations, we have these records. What are we actually pleading when we get to this motion? And here's a list, not exhaustive, just kind of some examples of the types of claims that you see in post-conviction. And I'm going to be going through some of these in more detail in a few slides. Ineffective assistance of counsel, Brady and Giglio claims, we'll talk about that in a second. Juror misconduct claims, prosecutorial misconducts, places where the state maybe did things that were inappropriate or unconstitutional. Changes in the law, things that have changed from the US Supreme Court, statutes, whatever that got changed since the trial happened. Newly discovered evidence, so evidence that we only found in post-conviction that maybe wasn't available at the time of trial. It could be a claim that the person who was sentenced to death should never have been sentenced to death. An example of this, we talked about before, if someone was intellectually disabled. If maybe the trial attorney just never put that, never pursued that at the pretrial proceedings, that can be a post-conviction motion. Also challenges to the death penalty statute in general, or instructions, kind of systemic claims. The importance of the claims that go in the 3851 motion, this post-conviction motion, can't be stressed enough, because you get one shot at it. If a claim existed at the time when you're supposed to be filing this motion and you fail to put it in the pleading, you're procedurally barred from going down that avenue forever. So it's very important in that year that you have to investigate, to find the records, that you are getting absolutely everything you need, because you need to put every possible claim of action in that petition, so you're not barred from pursuing it. So ineffective assistance of counsel. This is the Strickland case, Strickland v. Washington, discusses your Sixth Amendment right to have counsel. It means that you have a right to have effective counsel. Not just that you have a right to have an attorney, but you have a right to have an attorney that knows what they're doing. This is post-conviction bread and butter. There's a lot of other stuff, a lot of other good claims that we had listed, but Strickland, these ineffective assistance of counsel claims, you're going to be seeing these over and over and over again. And it's where we get a lot of our great stuff from. This is the test that is laid out in Strickland. It's the legal standard. Basically, the trial attorney has to be found to have deficient performance, and then has to determine that his deficient performance prejudiced the defendant at trial. That's the legal standard. That's not fun. But ineffective assistance of counsel can attack any part of the case. It can attack from failures of the attorney pre-trial, during jury selection, during the trial, guilt, penalty phase, anything. So it could look like failure to ask the appropriate questions during voir dire. It could be a failure to file a motion to suppress statements or evidence. It could be a failure to call a certain expert witness, failure to cross-examine a witness with a known bias, failure to conduct a reasonably competent mitigation investigation. So getting into everything you need to present to a jury and a judge to determine what the ultimate sentence should be. There are thousands and thousands of examples of Strickland cases. What I laid out two here for you, just to give you an idea of how it works in post-conviction. State v. Fitzpatrick, that was a case that was at my old office. It wasn't my case. Two of my coworkers had it, where they were able to have the Florida Supreme Court to say the trial attorney was found ineffective during the guilt phase, and because of that, the client was sent back to be given a brand new trial, everything. Basically, in Fitzpatrick's case, it was a first-degree murder and a sexual battery. The victim was found pretty conscious, but like very, very beaten up, obvious signs of sexual abuse, with clothing in her undergarments up around her chest area. At trial, the state testimony was basically there was evidence of a sexual assault and DNA was found inside of her. And the testimony was basically whoever sexually assaulted her was the perpetrator of the murder as well. Our client's semen was found inside of the victim. He told police that he had sex with her the day prior, but he never saw her after that. He was found guilty at trial and sentenced to death. And in post-conviction, the attorneys were able to do a couple of things. One, they brought on new experts that basically looked at the quality and the condition that the sperm was found. And they were able to date when the sperm, how long the sperm could have been inside the victim's body, which coincided with the client's version of events. Essentially that it had been there for more than 24 hours before her attack. And then they brought in some DNA testing that also showed that the client his story about having sex the day prior was consistent. So he was sent back for a new trial. He ended up not ever going to trial. They negotiated a plea and he was released. Raymond Bright, State versus Bright, was an example of a Strickland ineffective assistance of counsel in the penalty phase. In this case, the trial counsel basically just did a very reined-in penalty phase presentation. He wanted to present only the client's good qualities, didn't go into any sort of investigation about anything else that happened in his life. So he missed numerous examples of physical abuse, trauma, long documented history of mental illness, didn't seek out any sort of medical records, Baker Act records, didn't interview the family other than to ask what his good qualities were. He hired a mental health expert. The expert asked repeatedly for him to the trial attorney to look into other aspects of the client's case, pointing to specific examples, and the trial attorney just failed to do so. So in that case, the Florida Supreme Court found the attorney was ineffective, sent the case back for a brand new penalty phase. His guilt conviction was upheld, so he went back just for a new penalty phase trial. Brady and Giglio violation. So we touched on this briefly before. A Brady violation occurs when the state fails to disclose exculpatory evidence to the defense, which is material to guilt or to punishment. And then a Giglio violation, sort of similar, is when the state knowingly puts on false or misleading evidence that's material to the case. So both of these are things that have nothing to do with the trial attorney. They go to what the state is doing and their actions. The case I cited here, Trodell, I believe you pronounce it, it's an example. It has both Brady and Giglio violations that were present. He won in post-conviction and was sent back for a brand new trial. And under the Giglio violation, essentially two co-defendants, both charged with first-degree murder, tried separately and then sentenced to death. The Trodell's version is that his co-defendant was the one who basically was the trigger man and committed this, and he was forced to participate in the actual crime, but he did not pull the trigger. So at trial, at trial, the state put on an expert that said, based on gun residue tests that he did, Trodell was the triggerman because of the amount of gun residue that was on his hand. That same expert testified at the co-defendant's trial saying that you couldn't determine who was the actual trigger man in this case. So in post-conviction, the post-conviction attorneys used that to say the state basically was on notice that you could not determine who was the actual trigger man. And the saying that Trudell was the only trigger man at his trial was misleading to the jury. They put on an expert to basically confirm that, and that was where relief was granted under the Giglio. In Brady, there were numerous examples that post-conviction discovered that the co-defendant had beat a fellow inmate before his trial. There was a police report of an interview with a witness saying that the co-defendant had planned to kill this victim, and statements from the co-defendant's girlfriend saying that he was physically violent towards her months leading up to this crime. All of that was information that was never disclosed to the state, but was in possession. I'm sorry, never disclosed to the defense, but was in possession by the state and known by the state. The court here found that all of those violated Brady because they were material to the case as it went towards punishment. Because even though Trudell admitted that he was part of the crime, he was not the triggerman, and that's an analysis about whether someone should be, it's a mitigating factor in determining whether someone should be getting death versus a life sentence. Newly discovered evidence. Under this is something that can be pled in either the initial motion for to vacate judgment or sentence or any successives. So if newly discovered evidence is discovered after someone's initial pleading, there's mechanisms to get back into court to try to see it again. So this is the standard that's set out here, that it must have been known by the trial court, by the party at the time, it must not have been known at the trial court or the party or counsel, and that it must be such a nature that would probably produce an acquittal at retrial. So I have two examples here. I'm kind of running out of time, so I'm only going to focus on the one, Aguirre v. State. That was another case that came out of my office several years ago. In that case, Mr. Aguirre was convicted and sentenced to death in 2006 for the murder of two neighbors. He always maintained his innocence. He was the one who discovered the bodies but never reported it because he was an undocumented immigrant and he feared deportation. In post-conviction, collateral counsel did two things. One, they were able to find several people who the victim's daughter confessed to the murders to. They had an alternative suspect that the victim's daughter was the one who committed the murders. And they found about 5 or 6 individuals who she confessed to committing the murders to. They also had the blood at the scene retested for DNA, and the victim's daughter's DNA was discovered in the blood at critical parts of the crime scene. So all of this coupled together, the Florida Supreme Court stated that this would definitely undermine an acquittal at retrial, or a probability of an acquittal at retrial. So the case was sent back for a new trial. The state ended up dropping all charges 2 years later, so he never got retried, and he is out right now. So what happens after the motion to vacate judgment and sentence is filed? All of this. So the state gets to answer it. After the state files an answer, what a case management conference is held. At the case management conference, this is where arguments made about why certain claims need to have an evidentiary hearing. The judge eventually will issue an order granting or denying an evidentiary hearing on claims. An evidentiary hearing will be held if it was granted. An evidentiary hearing is essentially a mini trial with no jury. So it's an opportunity for the defense to put on all the evidence that they have developed in post-conviction in support of their claims. This can include any new witnesses. Always the trial attorneys have to are put on any sort of documentary evidence. The state in turn can put on their own evidence, and then the judge makes his determination. He'll make an order regarding the post-conviction motion. If he denies it, it gets appealed to the Florida Supreme Court. One note, I don't think I mentioned this before. At the time that the motion to vacate judgment and sentence is filed, the attorney-client privilege that exists between the trial attorney and the defendant gets waived, related to any claims that they put in that motion. And it has to, in order for the trial attorney to be able to get on the stand and talk about why he or she did certain things, didn't do certain things. So at that point as well, the trial attorney files that we received in our early investigations have to get turned over to the state attorney who's litigating in post-conviction. So it's a double-edged sword. Obviously, there's harmful things in trial attorney files as well as helpful things in post-conviction. But as it relates to certain claims, that privilege will get waived. After the order from the trial court, the case goes up to the Florida Supreme Court again. We can file 2 petitions at this point. We can file an appeal from the denial of the post-conviction motion, and then we can file something brand new, which is called the state writ of habeas corpus. In there, we can allege claims of ineffective assistance of direct appeal counsel. So any errors that the direct appeal counsel made right after trial when they first went up to the Florida Supreme Court. So this is our chart that we had before. We're in step 5. Once we get through the evidentiary hearing and take an appeal to the Florida Supreme Court, once we're done with the state post-conviction proceedings, we get to go into the world that I'm in now, which is federal habeas corpus, which starts at box 7. So federal habeas counsel, like the capital habeas unit, represents Florida state inmates sentenced to death in federal habeas proceedings in the federal district court, the 11th Circuit Court of Appeals, and the United States Supreme Court. We are filing what's called a writ of habeas corpus. That's the only writ explicitly protected in the U.S. Constitution. It's also known as the Great Writ. When we get a case, we are basically doing the same thing that state post-conviction counsel did. We are starting all over. We're getting records all over again. We're doing investigations prior to our filing of the federal habeas petition in the district court. This is the standard of relief that we are up against once we get into federal habeas litigation in state court and federal court. Technical, this could be its whole presentation itself, so I'm not going to be getting into this right now. But we're winding down. So why is post-conviction important? We've been talking now for 50 minutes. Post-conviction underscores principles of fairness, integrity, human rights, ensures all defendants are provided their constitutional rights to a fair trial, due process of the law, protects both innocent and guilty individuals from inherent human error in the criminal justice system, protects against wrongful convictions, illegal sentences, and other systemic errors. There's a lot of intentionally bad things that happen at trial and a lot of unintentional bad things that happen at trial. There are a lot of really bad trial attorneys out there, and there are a lot of really good trial attorneys that just don't get everything. There are a lot of things set up in the trial courts right now that make it very hard to execute due process and the fair trial standards which are required. So post-conviction puts a check on all of that and highlights where the errors were and who it came from. If it comes from the state, if it's coming from the court, if it's coming from the trial attorneys. One of the most important things about post-conviction is that Florida ranks #1 in the United States for death row exonerations. So right now, as of 2024, Florida's had 30 people from its death row exonerated, completely found innocent of their crimes, should never have been on death row to begin with. We have the most documented death row exonerations of any state. 22 out of 30 exonerated are people of color. And that basically means for every 3 people executed in Florida, 1 innocent person has been exonerated. And exonerations happen in post-conviction. And that's why it's important. And that's the end of my presentation. So are there any questions?
Yes, there are questions. One is, do you use paralegals for the document management, review, and research? What paralegal designation and education do you require of your paralegals?
We absolutely use paralegals in all of our records. In my office, our paralegals are the ones who submit the records requests, do the follow-ups. They're the ones indexing the records when they come in. They're usually the ones, and when we have team meetings, coming up with ideas of who should be asking for records. In terms of qualifications that they need or what kind of that I don't know. All of our paralegals are certified paralegals through the state. Their experiences they all have different backgrounds. We don't use a lot of specialized case management systems here. We're trying to get better ones. So it's a lot of just Adobe going through, scanning. But I rely on my paralegals a lot for give me ideas of where we need more records from, going through the records that come in to see if they're incomplete, who name people in there that we may want to interview. I also like using my paralegals for record comparisons, comparing what we received versus what was given at trial to see what was missing, things of that nature. So they are very much a vital role in this because it's impossible not to have a team effort with how many records are coming in.
Okay, and the final question is, how many cases are you typically handling at once, and how long do you generally have a case for?
So both great questions. So I right now have about 8 or 9 cases assigned to me. There are standards under the ABA of how many cases you're supposed to be handling in post-conviction, and I believe the number is 6 to 8 is what they would deem appropriate. Anything more than that can be overwhelming. These cases come at the paralegals have much more, I could tell you that, because there's way fewer paralegals in my office than there are attorneys. So they have much larger caseloads than I do. The cases come in different procedural stages. So not every case is very active. If one case has already gone through all of these stages of post-conviction, you're still working on it, but not as intensely as you would as a case that's brand new, coming right off of direct appeal, where you're really kicking it into high gear for the first year or two. The second part of the question, we keep the cases forever. We're appointed until we're either discharged for some reason by the court, if there's a conflict of interest or the client kicks us off the case for whatever reason. Otherwise, we keep the case until the client is executed, dies of natural causes, or is granted relief. So longevity in these positions is really helpful because these cases are really big, and to take over something that is already 30 years old is hard. But yeah, you're on the case for a long time, so.
Okay, we did have another question come in. How do you decide if someone's case is worthy of taking?
So we don't make a decision. My office is through, well, 2 parts. So in Florida, everyone is entitled to capital state post-conviction. So they are automatically appointed an attorney regardless. There's no worthiness evaluation in that. And they'll go to either designated offices, like sort of like a public defender system set up. There's 3 offices throughout the state. If those offices can't take it for any reason, they'll go to a private attorney on a registry panel. In federal court, so I'm in the capital habeas unit of the Federal Defender's Office, we are created to just take all cases that are available to us. So when someone is done with state post-conviction, we will go to them, or they write to us, or the court will appoint us. So there's no evaluation of the quality of their claims or their case. If there were, my job would be way easier because I'd pick really good cases, but this is not the case. We just take everyone. And that's part of the, that's part of the fun. It's a challenge, but, that's what we're here for, is the hard work.
Great, thank you. We are getting other comments that are saying not a question, but thank you for a great presentation, and they've really enjoyed your presentation. So thank you so much, Ms. Morley, and thank you everyone for attending today's webinar. The course number for today's webinar is 8446. Again, the number is 8446. This webinar has been approved by the Florida Bar Continuing Legal Education Department for 1 hour of general CLE credit and 1 hour of criminal trial and criminal appellate certification credit. Please self-report this course number in the member portal. You will receive an email tomorrow via Zoom outlining this information. I also encourage Florida Bar members and Florida registered paralegals to take advantage of the Florida Lawyers Helpline, which is completely confidential and free service, which entitles you to 5 counseling sessions per year to help you develop strategies to overcome life's challenges, balance priorities, and better handle both personal and professional pressures. This concludes today's webinar. Thank you.